Let's consider the crime of involuntary manslaughter. People v. Hall represents the first time in the country that a skier was charged with manslaughter for an unintentional death on the slopes. Nathan Hall, 18 years old, was described as an expert and aggressive skier, taking the last run of the day with some alcohol in his system. Going too fast for the hill, he was out of control as he skied down it. He crashed into a skier below with such force that Hall fractured Mr. Cobb's skull, and it was that single blunt blow to the head that caused his death. The kind of injury, the coroner reported, was typically seen in automobile crashes where the victim was thrown from the car. That's how much force Hall hit Mr. Cobb with. Procedurally, this is a different kind of case for us. Most cases we read in criminal law are appellate opinions that take place after a finding of guilt at the trial phase. Now the defendant's appealing. But this case took place before a jury was ever impaneled, before it ever went to trial. Here the prosecution charged Hall with manslaughter. Defendant appealed that charge. Now we have to decide, is there probable cause to bind him over for trial? Interestingly, both the county court and district court agreed with the defendant. It kicked the charge before it ever went to trial. It listened to the evidence, and it decided the prosecution had failed to meet its burden of proof of probable cause. That's the only burden of proof prosecution must meet for a defendant to stand trial. For a conviction, we know we need to meet beyond a reasonable doubt. But at this stage of the proceedings, just to bind someone over for trial, there must only be a finding of probable cause. Both lower courts agreed that there was no probable cause. When the Supreme Court of Colorado intervened, in the opinion we're reading, it was only for the limited purpose of deciding whether there was enough evidence to present the case to a jury. It didn't decide whether Hall should be convicted of manslaughter, only whether the facts are sufficient to go to a jury. The Supreme Court found that the facts were sufficient to bind Hall over for trial. There was probable cause. And in a trial shortly afterward, Nathan Hall was found guilty by a jury of 7 men and 5 women, all experienced skiers or snowboarders. To decide whether this kind of case could be presented to a jury, the Supreme Court spent equal time defining the law of manslaughter and then analyzing the specific facts to see whether Hall's behavior was a gross deviation from the standard of care which constitutes manslaughter. Let's first take the law. A word here about terms. For the purpose of our class, we're going to consider involuntary manslaughter as it was developed a common law and then codified by the states. Now we know that some states have adopted the Model Penal Code's view of manslaughter, which has several gradations of this crime depending upon the mental state of defendant. But for our purposes, we're going to speak of involuntary manslaughter using the more basic definition. That requires the defendant's conduct demonstrate a substantial and unjustifiable risk of death or serious bodily harm. It's not that someone's going to die from this behavior. Instead, it's all about the risk the behavior presents. Another word about terms. We use the term gross negligence, but sometimes you're going to read a case that says criminal negligence or even recklessness in some situations. I want us all to think of those 3 words meaning the same thing, a substantial and unjustifiable risk. But the question of substantial risk, it's a difficult one to ponder. Substantial, the court in Colorado says, doesn't mean a probability of death. That's where the trial court went wrong. It doesn't have to be more likely than not that Hall was going to cause a death. In fact, in this case, it's probably a very low risk of death. We would need a perfect intersection of terrible factors happening together. Hall skiing down the hill out of control, Cobb coming right into his pathway for that death to happen. So the court says an identifiable risk, it could be low, as in actually hitting somebody. But if the magnitude of the harm is so high, if Hall hits someone, then taken together, the likelihood plus the magnitude can produce a substantial risk. We're looking at the relationship between the likelihood of the event happening, that's Hall hitting someone, and the magnitude of the harm if, God forbid, he does hit somebody. Let's take an example to play this out. Suppose I'm walking very fast down the sidewalk of a very busy street in a major city. It's lunchtime and the crowds are thick on the sidewalk. I'm now running down the street to catch a bus or to make it to an appointment. With the crowds so thick, what are the chances that I'm going to bump into somebody? Probably very high, maybe even jostling them. That's the likelihood of the event happening, okay? We know that's settled. But what's the magnitude of the harm if I do run into them? I think it's probably quite low. Nothing much is going to happen. Hardly a chance that death or serious bodily harm is going to occur if I'm jostling them. That won't be a substantial risk of death, even though it's very likely that I'm going to hit somebody's arm or their body as I race by. That's because the magnitude of the harm is so low. In Hall, we have the opposite. The likelihood of Hall actually hitting somebody is less than my example. And again, that's where the trial court got it wrong. Of course, it's going to depend on how crowded the slopes are. If the slopes are thick with people, then the likelihood of Hall hitting somebody is actually pretty high. But even if that's not substantially likely, the court says the magnitude of the harm might create the mens rea of gross negligence. Why? If Hall hits someone because he's going so fast, chances are the accident is going to be catastrophic. And here it was. Consider the testimony by the witnesses and the coroner to testify how fast Hall must have been going when he hit Cobb. Whether people actually saw the accident or not, their testimony is relevant to show how dangerous Hall was by his acts, what they perceived when he was going down the mountain. Look at all the words that were used to show that Hall was behaving recklessly on the slopes, that he was out of control. Judge Allen testified that he himself was an expert skier and that Hall was traveling 3 times as fast as he was going, whizzing right past him. As an aside, didn't you just shake your head when you saw that this witness was a judge? Defendants know they're in trouble when the witness against them is a judge who lives in the area. Bruce Yim, another witness, reported that Hall was skiing too fast, that he was out of control. Another skier reported being struck by Hall after the collision with such a force that Hall broke one of his poles in half. The court summarized all of this by saying that Hall's excessive speed, his lack of control, improper technique for skiing bumps significantly increased the likelihood of a collision, and with that, the magnitude of the harm, the chance of death. That's a great example of explaining this ratio of likelihood of the event occurring with the magnitude of the harm if the event does occur.